I hope everyone is doing well at their end. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be discussing on the topic Doctrine of Basic Structure in the Indian Constitution, a Critique. Let's begin with an introduction. Social, economic and political conditions of a country is susceptible to the change. With the changing times, problems of a nation take various forms and dimensions. The conditions which existed at the time of the drafting of Constitution may not be same over the period of time. Therefore, it becomes very imperative to have the same procedure wherein the Constitution may be adapted from time to time in accordance with the needs of the nation. This procedure of adaptation is called the amendment of the Constitution. The constitutional amendment ensures that the provisions and the interpretation of the Constitution remains relevant in the changing times as well. The methods of reconciling the Constitution with the changing needs can be classified into two broad categories, that is, informal method and formal method. Let's discuss these methods one by one. First is informal method. This method cannot be called amendment in a strict sense of term because the constitutional text does not undergo any change. In this method, the judicial interpretation of the Constitution undergoes a change. It is a process of judicial interpretation which assigns new meaning to the existing text. It is a slow process and develops on case-to-case basis. Second method was the formal method. This method consists of a formal process of amendment of the Constitution by changing the text of the Constitution. Depending upon the procedure of amendment, it can be classified into again further two types, that is flexible and rigid. In case of flexible Constitution, those are the ones in which the process of amendment is quite easy. The Constitution can be changed by ordinary legislative process. It is just like enacting an ordinary law. For example, British Constitution can be amended by ordinary law of Parliament. In flexible Constitution, there is no distinction between ordinary legislative process and constituent process. But on the other side, when it comes to rigid Constitution, the process of amendment is more elaborative and difficult. Constitution cannot be amended like an ordinary law. A different set of procedure is laid down for the amendment of the Constitution. In a rigid Constitution, there is difference between ordinary legislative process and the constituent process. Now, after discussing about these amendment things, let's talk about the doctrine of basic structure in India. The term, the word basic structure is not expressly mentioned anywhere in the Constitution of India. It has evolved through the judicial interpretations time to time. It was first enunciated by the Supreme Court of India in the very historic 1973 case of Keshavananda Bharati versus State of Kerala. The basic structure doctrine holds that there are certain fundamental features or basic elements of the Indian Constitution that cannot be amended by the Parliament. These essential features form the foundation and the essence of the Constitution and cannot be altered or destroyed by any amendment, including the ones which are given under Article 368 of the Indian Constitution, which provides for the power of the Parliament to amend the Constitution. The doctrine further provides a limitation on the amending power of the Parliament and ensures that the protection of core principles and values enshrined in the Constitution. It acts as a safeguard against any arbitrary or excessive amendment that may seek to alter the basic structure of the Constitution. The specific elements that constitute the basic structure of the Indian Constitution have not been exhaustively defined by the courts, allowing for flexibility and evolution over the time. However, some commonly accepted components of the basic structure includes supremacy of the Constitution, rule of law, separation of powers, judicial review, federalism, secularism, protection of fundamental rights. The basic structure doctrine has played a significant role in shaping the Indian constitutional law. It has been used by the Indian judiciary to strike down several constitutional amendments that were deemed to violate the basic structure. The basic structure doctrine is not explicitly mentioned in the text of the Indian Constitution. However, it has been developed and recognized as a legal principle by the Supreme Court of India through its interpretation of various constitutional provisions. The doctrine finds its roots in the landmark case of Keshavananda Bharati versus State of Kerala. In this case, the Supreme Court held that although the Parliament has the power to amend the Constitution under Article 368, such amending power cannot be used to destroy or alter the basic structure of the Constitution. While the doctrine is not explicitly mentioned in the Constitution, it derives its legitimacy from several constitutional principles and provisions. Some of the key provisions and principles that form the basis for the basic structure doctrine are: number 1, the preamble. The preamble of the Indian Constitution enshrines the basic principles and objectives of the Constitution, such as justice, liberty, equality, and fraternity. The basic structure doctrine draws its strength from the idea that these principles are foundational and cannot be tampered with by the amending power of the Parliament. Another point regarding the fundamental rights. Part 3 of the Constitution guarantees the fundamental rights to all citizens. These rights include the right to equality, freedom of speech and expression, right to life and personal liberty, and many more. The basic structure doctrine protects these fundamental rights as an essential component of the basic structure of the Constitution itself. Then, another provision relates with the directive principles of state policy. Part 4 of the Constitution contains directive principles of state policy, which are the guiding principles for the government to promote social justice, equality, and welfare. The basic structure doctrine ensures that amendments cannot compromise with the core principles and objectives of the directive principles. Another point regarding the separation of powers. The Constitution establishes a system of separation of powers between the legislature, executive, and judiciary. The basic structure doctrine protects this separation of powers as a fundamental feature of the Constitution, ensuring that no single organ of the government becomes disproportionately powerful. Judicial review. The power of judicial review is implicit in the Constitution, allowing the judiciary to interpret and uphold the Constitution. The basic structure doctrine empowers the judiciary to review and strike down the constitutional amendments which violates the basic structure theory. The doctrine of basic structure is a key constitutional principle in India, which limits the power of the Parliament to amend certain fundamental features of the Constitution. According to this doctrine, certain core principles and values cannot be altered through the constitutional amendments even. The Supreme Court of India has used the basic structure doctrine to strike down several constitutional amendments over the years. Now let's give some light and some focus on the judicial interpretation of doctrine of basic structure. First Amendment Act of the year 1951. The Constitution of India was amended as early as in 1955, which introduced Article 31A and 31B to it. Article 31B inserted the 9th schedule, which stated that any law provided under it could not be challenged for the violation of fundamental rights under Article 13 Clause 2 of the Constitution. Article 13 Clause 2 states that the Parliament shall not make any law which abridges the rights conferred under Part 3 and to the extent it shall be void. A petition was therefore filed in the Supreme Court of India challenging Article 31A and 31B on the ground that they abridge or takes away the rights which is guaranteed under Part 3 of the Constitution and which is against the spirit of Article 13 Clause 2, and therefore it should be declared void. Then came a very landmark case, that is Shankari Prasad versus Union of India. The Honorable Supreme Court of India held that the power to amend the Constitution, including the fundamental rights, is conferred under Article 368. And the word law, as it is mentioned under Article 13, Clause 2, does not include the word amendment of the Constitution. There is a distinction between Parliament's lawmaking power, that is the legislative power, and the Parliament's power to amend the Constitution, that is the constituent power. After going on with this case, another landmark judgment that came before the Supreme Court was that of Sajjan Singh versus State of Rajasthan, a 5-judge bench which dealt with the validity of 17th constitutional amendment, which had added nearly 44 statutes to the 9th schedule. The decision of Shankari Prasad case was reiterated in the Sajjan Singh case. It held that Parliament has the power to amend the fundamental rights. Now came the transition. Now came the U-turn. Golaknath versus State of Punjab. Very landmark case. In this case, the Supreme Court by a majority of 6:5 held that the fundamental rights were outside the purview of the amendment of the Constitution. It was observed that the power of Parliament to amend the Constitution does not subside within the ambit of Article 368. It was very clearly stated that Article 68 only provided for the procedure of amendment and nothing more. The court also clarified that the word law, as given under Article 13, Clause 2, includes within its meaning an amendment to the Constitution. Therefore, any amendment against the fundamental rights would be void. However, the 1st, 4th and 17th amendments were not declared invalid by the court, as the ruling was given a prospective effect. This meant that no further amendments could be brought into the Constitution violating the fundamental rights. A very important constitutional amendment, that is 24th Constitutional Amendment Act. The decision in the Golaknath case created many hurdles in the country. Therefore, the Parliament enacted the 24th Constitutional Amendment. The Amendment Act not only restored the earlier position but also extended the powers of Parliament. A new clause, that is Clause 4, was added to Article 13, which stated that nothing in this article shall apply to any amendment of this Constitution made under Article 368. It also inserted a new clause to Article 368, which provides that, notwithstanding anything in this Constitution, Parliament may, in the exercise of its constituent power, amend by way of addition or variation or repeal any provision of this Constitution in accordance with the procedure laid down in this article. Now, finally came the most landmark judgment of the Constitution, that is Keshavananda Bharati versus State of Kerala. This case was initially filed to challenge the validity of Kerala Land Reforms Act of 1963. But the 29th Amendment of the Constitution placed it under the 9th schedule. The historic judgment was delivered by 13-judge bench with a majority of 7:6 ratio, and it totally overruled the Golaknath verdict. It was held that power of Parliament to amend the Constitution is far and wide and extends to all the provisions of the Constitution, including the fundamental rights, but it cannot destroy certain basic features or the framework of the Constitution. Moreover, the court upheld the validity of 24th Amendment Act. It does not enlarge the powers of Parliament. Article 368 always included the power and the procedure to amend the Constitution. But the question was, what constitutes the basic structure? It was not even laid down in this case. It only provided an illustrative list as to what may be constituted in the basic structure. According to Justice Sikri, the basic structure constitutes the following elements: the supremacy of the Constitution, republican and democratic forms of government, secular character of the Constitution, separation of powers between executive, legislature and judiciary, federal character of the Constitution. According to Justice Sheelat and Justice Grover, the following were included in the basic structure. That is, the mandate to build a welfare state contained in the directive principles of state policy, maintenance of unity and integrity of India, the sovereignty of the country. Then, according to Justice Mukherjee and Justice Hegde, they had their own list of the elements for the basic structure, which included the sovereignty of India, the democratic character of the polity, the unity of the country, essential features for individual freedom, and the mandate to build a welfare state. Whereas Justice Jagan Mohan, he believed that it was the preamble that laid down the basic features of the Constitution, which further included a sovereign, democratic and republic character, the provision for social, economic and political justice, liberty of thought, expression, belief, faith and worship, and equality of status and opportunity. This is how, in the Keshavananda Bharati case, different judges gave their different opinion as to what is included in basic structure and what not to be included. Indira Nehru Gandhi versus Rajnari. It was the case in which the faith in the doctrine was affirmed and established. In this case, the appellant had filed an appeal against the decision of Allahabad High Court invalidating the election as the Prime Minister. While the appeal was still pending at the Supreme Court, the 39th Amendment to the Constitution was enacted and in force, which stated that no court will have the jurisdiction over the election disputes of the Prime Minister. The court, relying on the decision of the Keshavananda Bharati case, stated that democracy was an essential feature of the Constitution and thus it forms the part of basic structure. The bench also added certain other features to the list of basic structure, which was rule of law and the power of judicial review. Later on, in the case of Minerva Mills Limited versus Union of India, the Supreme Court provided clarity to the doctrine and laid down that the power of Parliament to amend the Constitution under Article 368 is limited and exercise of such power cannot be absolute. A limited amending power was very well part of the basic structure doctrine of the Constitution. Furthermore, the harmony and balance between fundamental rights and directive principles are also the part of the basic structure. And anything that destroys the balance is an ipso facto violation of the doctrine. One more case, that is of L. Chandrakumar versus Union of India. In that case again, it was stated that the power of judicial review under Article 32 of the Constitution and under Article 226 of the Constitution is a part of the basic structure doctrine, and these powers cannot be diluted by transferring them to the administrative tribunals. Moreover, in the year 1981, in the case of Vaman Rao versus Union of India, the Supreme Court reiterated the basic structure doctrine and held that the power of judicial review is an essential and integral feature of the Constitution's basic structure. The court struck down certain provisions of the 42nd Amendment Act, which sought to curtail the scope of judicial review. Another landmark and historic judgment turned up in the year 1994, that is S.R. Bommai versus Union of India. The Supreme Court once again applied the basic structure doctrine in context of federalism. The court held that secularism and federalism are basic features of the Constitution and cannot be abrogated by the Parliament. The judgment clarified that any attempt to undermine the democratic fabric or secular ethos of the nation would be deemed as violating the basic structure. Then came the judgment of 2016. Supreme Court advocates on record association versus Union of India. One of the very recent cases on the basic structure is that of the National Judicial Appointments Commission, that is NJAC case, also famously known as 4th Judge's case. By the virtue of 99th Constitutional Amendment, the Parliament replaced the mechanism of selection of judges with the National Judicial Appointments Commission, that is NJAC. The initial composition of NJAC was thought to be comprising of Chief Justice of the Supreme Court along with 4 senior-most judges of the Supreme Court. However, at the same time of enactment of the NJAC Act, the Commission was composed of the Union Minister of Law and Justice and 2 eminent persons alongside Chief Justice of India and 2 senior-most judges. As a result, petitions were filed challenging the constitutionality of the amendment and the NJAC Act, raising the concerns that the impunged law affected the independence of judiciary and caused lack of transparency as well as accountability. By a ratio of 4:1, the majority view held that the said amendment and the Act were violative of the basic structure doctrine since it affected the independence of judiciary by including the executive in the selection process of judges. Now let's talk something about the arguments in favor of the doctrine of basic structure. Time and again, the High Courts as well as the Honorable Supreme Court have held that the basic structure of the Constitution is one of the most crucial aspects in the largest democracy of the world. It ensures that nothing in the country is above the Constitution and the Constitution is indeed the supreme law of the land. The non-definite structure of the doctrine provides that the judiciary an opportunity to apply the Constitution in its true sense. After the landmark verdict of Keshavnanda Bharati, the basic structure of the Constitution has been kept intact by various courts. There are certain provisions of the Indian Constitution which forms the core and basic values on which the Constitution rests, and they cannot be altered or removed from the Indian Constitution. Such parts of the Constitution forms the basis and reflects the principles of the makers of the Constitution. Not only that, but also they throw light on the basic tenets of constitutionalism in India. Now let's have a discussion about the arguments that goes against the basic structure doctrine. The basic structure doctrine is often criticized for the reason that it does not find its roots in the constitutional text. No provision of the Constitution, neither expressly nor implicitly, discusses about the basic structure. The critics believe that the constitutional value of sovereignty of people is the supreme power which vests with the democratically elected government. Any judgment overturning such power of people shall thus be against the spirit of Constitution. The Constitution emphasizes on the separation of powers among the functionaries established thereunder. As much as the legislature does not have the power to pen down the verdict of a case, the judiciary also does not have the power to declare any constitutional amendment as void. Now let's come to the conclusion. The basic structure doctrine provides an overhauling power to the judiciary. The makers of the Constitution endowed the responsibility of protecting the true values of the Constitution upon the judiciary itself. Thus, the judiciary has to protect and uphold the true values of the Constitution. Thus, the judiciary has to protect and uphold the true values of the Constitution. If these values themselves are amended by the legislature, it would be detrimental to the spirit of Constitution. These values are what forms the basic structure of the Constitution. However, the biggest problem faced while protecting the basic structure is that it has not been clearly defined anywhere. The basic structure is also found in various other democracies. Since the scope of the basic structure is defined in these countries, the scope of criticism is limited. Therefore, a definite basis of the basic structure is the need of an hour. The basic structure doctrine grants the fine balance between flexibility and rigidity that should be present in the amending powers of any constitution. Thank you everyone for your time and attention. It was a great pleasure explaining you about the doctrine of basic structure in the Indian Constitution. We have discussed the concept in a short span of time, and I hope that all the listeners have enjoyed and understood the topic. Stay safe, stay healthy. God bless you all. Take care.